go to national origin discrimination. We've talked about sex, we've talked about race, we've talked about religion, okay? You can't discriminate on the basis of national origin. And there are a couple laws that we want to talk about specifically when it comes to national origin discrimination or illegal immigration discrimination, all right? And I'm not going to talk in terms of all the laws that require you to fill out certain forms. I just want to talk about the discrimination laws right now on that. One of the laws that you need to keep in mind and be familiar with if you're practicing in human resources or in management is the Immigration Reform and Control Act. It is the Immigration Reform and Control Act. Okay. This was an act established in 1986. In some respects, it toughened criminals or sanctions, okay, toughened sanctions for employers who hired illegal aliens. But in part, it also, and where we're going to focus, it also discriminates or prohibits employment discrimination based on national origin and citizenship. Okay? Now, just to make sure we're clear, somebody explain to me the difference between national origin and citizenship. Yeah, okay.
National origin is where you were born or what country you're from. Citizenship is what country you claim is yours.
Okay, and what country you have. I mean, whether you're citizens or not. Okay, very good. All right, national origin, basically, as Tom says, is where you're from. Okay, citizenship is what country you claim as yours. All right. Now, the Immigration Reform and Control Act, IRCA, prohibits discrimination both on the basis of national origin and on the basis of citizenship. Now, interesting, most of the laws that we've talked about, at least as far as Title VII goes, or the federal laws, require how many employees before they apply? Federal laws. 15. All right, most of the laws that we've talked about so far, 15. There have been a couple of exceptions, but most of them, 15 employees. The Immigration Reform and Control Act protects only employers from 4 employees to 14 employees. Okay? The national origin protections of the Immigration Reform Act, or Reform and Control Act, only apply to employees who have between 4 and 14 employees. Why not more? Why didn't it apply to those with 15 or more?
That's when Title VII would.
There we go. Yeah, that's when the federal law kicks in. Okay? So there's no reason. Now, that's not always the case in our laws, but yeah, that's exactly right, Jackie. That's when Title VII kicks in. So for national origin protections, it only applies to employers with 4 to 14 employers, okay? Prohibits discrimination from 4 to 14 as national origin. When it comes to citizenship discrimination, it applies to any employer with 4 or more employees. So now why doesn't the Immigration Reform and Control Act stop at 14 employees with regard to citizenship discrimination?
Citizenship isn't really covered under Title VII.
Citizenship, as Jackie says, is not covered under Title VII. Okay? So it really is consistent in that regard. But national origin, 4 to 14, citizenship, any employer with 4 or more employees. Okay? Now, illegal aliens and aliens who are eligible but do not apply for naturalization within specific periods are not protected. And somebody asked me this, and then they've read it exactly right. If you're an illegal alien or you're not applying for the proper protection, okay, or the proper status, I should say, then the act does not apply to you. Here is the key, however. Just because that act doesn't apply to you doesn't mean that Title VII doesn't apply. Because Title VII also applies to illegal immigrants, okay? Illegal aliens. Jackie?
Why?
I don't write the laws. Just the way it is. From personal, it doesn't make much sense to me, okay? But it is clearly Title VII has been deemed as providing coverage to everyone. And I think what it comes down to is the law doesn't spell out who it applies to or doesn't apply to. It says that they're an employee. Okay? So if you take a true reading of the law and who it applies to, it doesn't have an exception that says you have to be a United States citizen or a proper, have proper status, legal status, in order for the law to apply to you.
It just seems sort of bizarre when it's like we're going to sanction you if you hire illegal immigrants, but we're going to protect them if they're discriminated.
Well, and yes, in one hand it does, but if you carry it out, it almost in a bizarre sort of way makes sense, because as you say, in one hand it doesn't make sense that you say we're going to punish you if you hire them, and yet then we're going to make it. In a way, it really does, because it says you're the one who hired him in the first place.
That's fair.
Okay? So if you're going to hire him, by God, you're going to live with the consequences.
Okay.
So you better not discriminate against him.
Yeah,
You know.
that makes sense.
Okay? So, yeah, I mean, it does. I think really what it comes down to is the law doesn't carve out whether Title VII applies or doesn't apply, and so the courts have said, hey, it applies until the law tells us different. Okay? But basically, the IRCA, okay, the Immigration Reform and Control Act, allows complaints to be filed by citizens who are, or by U.S. citizens or nationals, okay, people who are U.S. citizens, aliens who are lawfully admitted for permanent residence or granted asylum, okay. It does not apply, as we've kind of addressed, to those who do not apply for naturalization when they could within their first 6 months, or have not become naturalized as citizens within 2 years of their application, even though they could have. The law specifically, however, does allow for employers to give hiring preferences to citizens over equally qualified non-citizens. So if you have two people who are equally qualified, you do not have to give it to the non-citizen. Okay. Now, in general, so that's the IRCA. There's a lot of other things and some enforcement remedies, and I don't want to get that specific on those, but that's basically the IRCA. Now, then you have Title VII. Okay, it is and national origin is generally prohibited both by Title VII and also by the state acts, such as the Missouri Human Rights Act. It extends to all workers in the United States, and as we just discussed, it also applies to illegal immigrants. Just like race, just like sex, just like religion, it prohibits disparate treatment, disparate impact, hostile environment, retaliation. Okay? And you have the same defenses. Okay, bona fide occupational qualification, business necessity, as we've talked about. Now, a little bit different, a little bit twist on the national origin that I want to go over and above what we talk about with regard to the other is language issues, foreign language requirements or English requirements. Okay. And basically, the law says it is okay to make the ability to speak and understand English a job requirement. As long as it really is a business necessity. And you better be applying those laws equally. So if you're in management, you're human resources, you got to make sure you apply. Now, where you get in trouble with English-only rules, it may be okay to have an English-only rule for most situations. Where you get in trouble with English-only rules is where you apply those English-only rules to situations where it is not a business necessity. So, for instance, let's say in a regular job you require English-only rules. Perfectly fine. But when the person goes on break and is talking to somebody else in a foreign language, so to speak, and they're just talking, probably not okay to prohibit them from doing that. Does that make sense? Okay. So as long as there's a business reason for it, as long as there's a business necessity, it probably is not good enough to say as a supervisor, well, they may be talking about me and I don't know that. And so therefore, I don't want anybody doing that. Okay. Probably not going to cut it. But as long as it's necessary for the job in any respect, probably okay. Just be careful about like the break times or having a blanket policy that you can never speak a foreign language. Couple of exceptions real quick, and we'll on those. Title VII does allow for employment preferences based on national origin if the job or the work site where any part of the job is performed is subject to national security requirements. Okay. Again, the security requirements. And the particular individual has not met those. So it's the national security bona fide occupational qualification. Okay. Any questions on national origin? All right. Let's talk about age discrimination then for a little bit. Throw another wrinkle. Age discrimination is wrinkle, pardon the pun. Age discrimination is prohibited by the ADEA, the Age Discrimination in Employment Act, and again, state laws. Okay. Now, for the wrinkle, how many employees do you have to have in most of these laws that we've talked about on a federal level? 15, all right? The ADEA requires 20 employees. Okay? So you got to have 20 employees in order before that law kicks in. When you talk about the age discrimination, what are the classifications? Anybody remember what the age group is?
40 plus.
40 plus. All right. So if you are in 40 or above, then you are in a protected class for the age discrimination. Now, keep in mind, age discrimination laws, and somebody asked me this question, it's a good question, but age discrimination laws only protect discrimination against the group, not against those who are outside the group, right? So if you're 30 and somebody tells you that you didn't get the job because they're giving it to a 40-year-old, and the only reason you didn't get the job is because of your age, and you're under 40, all right, no discrimination, no illegal discrimination. Is it age discrimination? Sure. Is it based on the fact that you're too young? Sure. Is it illegal? No, because you don't fit in that group, okay? And the group is 40 or above. Now, keep in mind, discrimination can be shown even when the employee who gets the job is in the protected class. You with me? If I'm 50 years old and I don't get a job, and the person who gets the job is 49 years old, are both of us in that protected class? Yes. Do I still have an age discrimination claim? If I can show. Now, look, I got to show my case. I got to be able to prove my case. But if I can show that they don't hire people who are 50, okay, I can still have an age discrimination claim. Now, you don't see it in the example that I drew as much as you'll see it where you have somebody who's 60 years old, okay, being getting a job taken away from them or being replaced or being filled by a person who is 40 years old, okay? So the 40-year-old is still in that protected class, but that doesn't mean the 60-year-old can't sue on the basis of age discrimination. Somebody asked me, using that example, somebody said, well, what if we have somebody who is 40 years old and somebody who is 60 years old, who gets more damages, or which one's a better case? In some respects, the person with the 40-year-old who doesn't get the job may actually have more damages. Why?
They have a longer period of time that they could collect that amount of money.
Yeah, absolutely. Theoretically, they have a longer period of time that they can collect on amount of money. Now, there are other issues, argue why they shouldn't, why the 60-year-old should have more damages than the 40-year-old.
Because the protection is, in spirit, kind of greater as you're older.
Yeah.
So it's like you should get more damages because you've been more heavily discriminated against and you're more protected.
You're more heavily discriminated against, okay, but what's my chances of getting another job if I'm 60 versus if I'm 40? Probably not as good if I'm 60 as if I'm 40, okay? Doesn't mean I can't, but probably not as good. So it can work both ways, but just because you're older doesn't necessarily mean you'll have more damages. Quite frankly, if I were in private practice, I would prefer to take somebody who was older because I think it's going to be more sympathetic. Particularly, I got to the point my last 2 years, I mean, you look at 2008 on, everybody was losing their job. So it was real hard. I became very selective as to which cases I took because I was going to be arguing to a jury and saying that somebody had been discriminated against and lost their job. How many people on that jury was going to know somebody that had lost their job, okay, and hadn't got any compensation for it? And those became tough cases during that period of time. So we had to be very selective which ones we prove. But again, doesn't have to be in a particular age class. In other words, if they're both in the same age class, you can still have age discrimination. Okay. Now, the one thing about age, for the most part, is it has to be the exclusive reason you were terminated under federal law. In order to prevail under federal law for age, it has to be the exclusive reason that you were terminated. For the other laws on the federal basis, have we talked what the standard was?
Prevailing?
You have to prevail, but did we talk about contributing? Because the example that I use, and I don't recall if we used it in here, when I talk about contributing, what I would sometimes do with a jury is say what you have to show, or what you have to come to the conclusion is that their race contributed to the reason that they were fired. And I would sometimes take a piece of paper and tear that piece of paper and say, me tearing this piece of paper has contributed this little part here, being away from this, has contributed to this paper being damaged. Okay? And that was kind of the example that we sometimes use. And so it really didn't have to be an exclusive. For age, okay, it has to be the exclusive reason. We had a case, I won't tell you where, because we won on summary judgment, but I don't know if we then we may have done a confidentiality agreement on it, so I won't talk about where. But we had a guy who filed a lot of claims against our particular employer. One of those was a whistleblowing claim because he saw somebody being beat up, okay? And he reported that. He saw one of the employers beating somebody up, and he reported that. So he says. Now, I took his deposition, and I said, well, what did you say? He said, well, I didn't say anything. And I said, well, how did you report it? He said, I shook my head no. And so we proceeded along those lines, and basically what his belief was that he shook his head no in disapproval, and therefore his employer saw that he was disapproving that this particular person was being beat up, and therefore that violated his whistleblowing rights. And he said he was terminated for whistleblowing. Okay? Now, in that same lawsuit, he also claims that he was discriminated against on the basis of his age. Okay? So when we took his deposition, I asked the question, all right, so how much of it was because you were whistleblowing? And he said, well, I think it was part of it. Well, how much of it was your age? Well, that was part of it. So was it both your age and whistleblowing? Yeah, I think that's it. Bottom line is, just by saying that it was part of it and part of the whistleblowing, we got rid, or could have gotten rid, I don't know that that's the reason we eventually won, but we could have gotten rid of the age discrimination as well, because it wasn't the exclusive reason. Okay? And in that particular case, they only filed the federal claim. They did not file the state claim. So when I say that age has to be exclusive, keep in mind, I'm only talking federal. You with me? Okay? Because on the state laws, it may be different. State laws, it may be different. Okay. Defenses are very similar to what we've already talked about, so I'm not going to spend a lot of time rehashing those. Bona fide seniority system. If you have a bona fide seniority system, you can discriminate against somebody on the basis of age. Okay? And you may think, well, how would that work, right? Although if you hired somebody in who's 50 and they've only been there 5 years, but you have somebody who's 48 or 45 who's been there 20 years, and based on the seniority system, the person who's 45, or even get it outside the protected class, who's 30, but has been there 10 years as opposed to the person who's 50 but been there 5 years, you may be able to treat the person who's outside that class better. Okay? So bona fide seniority system will in fact be a defense. Bona fide occupational qualification. Where may there be bona fide occupational qualifications? So that age, so that you can't hire on the basis, or so that you can discriminate against somebody who's older.
I think there was a text example where the flight engineer couldn't be over 60 because of health concerns.
Correct. Okay. Yeah. If you've got certain reaction times, okay, and interesting, it is not in every flight situation. So, or not every aviation job. So there are some aviation jobs where age might be a bona fide occupational qualification, but other jobs where it would not be a bona fide occupational qualification. Okay? All right. What else?
Certain military jobs.
Certain military jobs. Okay? Certain military jobs might have that. Police jobs, law enforcement, or firemen. Why might law enforcement or firemen have some? Why might age be a factor in those, or a bona fide occupational qualification?
They might have certain physical qualifications that they need to make or meet,
right.
And qualities deteriorate?
Correct. And so generally you're not going to be able to do that, or the courts will say, hey, the statistics are just there that that's a legitimate bona fide occupational qualification. Okay? And then finally, if you can just show that, hey, they just didn't do their job, or that there was a reason other than age. Okay? You're always allowed to show a reason other than age. Okay. Now, just kind of to keep you on your toes here, something that we haven't talked about in the others, but really can apply in the others, is this idea of after acquired evidence. And I want to throw that out here. We haven't spent a lot of time, I don't think we spent any time talking about it, but I want to go ahead and discuss it here. Any idea what after acquired evidence is? Anybody want to take a guess?
Is it something that comes to light after you've had your trial?
Yeah, almost, Darla. It's really close. It's something that comes to life after, or comes to light after you have already taken some action. Okay? So let's say that I work for you and you find that I'm a real pain in the whatever and you fire me. Okay? And I turn around and I say, you know what, Darla, I think you are discriminating against me on the basis of my age. Okay? And lo and behold, I've actually got a witness there, Crystal, who says, yeah, I heard Darla say just the other day, I'm going to fire Greg because he's an old man. Okay? Now, in the process of discovery, or afterwards, you go, man, we got to find another reason to fire him. And you don't manufacture it, but you're looking at my application, and it says, have you ever been convicted of a crime? And I say, no. And through the process, you find out, yeah, I in fact have been convicted of a crime. Now you may be able to justify the termination, or at least decrease the damages because something new has come to light. Okay? And that's what we call after acquired evidence. Now, it won't work in every single case. It's not something you want to be relying on. You better have the facts right the first time. But every now and then it'll help you as a manager or as an employer get out of a sticky situation if you can find, or if there is in fact after acquired evidence. Now, having said that, right now there is a push with the EEOC to say criminal background checks are no-no. And you shouldn't be relying too much on criminal background checks. Just as an aside, I'm not, because that's the new thing we're seeing right now. Okay. But after acquired evidence frequently can come and help you out. Okay. Now, let's talk about mandatory retirement for just a minute. Generally, it is prohibited. There are some situations where it is not prohibited. Okay. But generally, mandatory retirement is prohibited. There is what we call an executive exception. An executive exception. In order for this exception to apply, basically you need three things. You need an executive who is at least 65 years of age. So you can't force retirement under somebody who's not 65 years of age. You need an executive who is at least 65 years of age. Second, this executive had to have been an executive in that position for at least 2 years. And third, and here's why it generally doesn't happen, you have to pay retirement benefits of at least $44,000. Now, most of the time, people aren't going to do that. Okay. Basically, they'll offer buyout clauses or severance pay, and you'll sign an agreement saying, "Hey, I won't sue if I get X amount of dollars." Okay. You don't see a lot of these executive packages, but you see them from time to time. But in order, yeah, I mean.
Is that amount like a federal amount, or does it vary based on states?
No, it's
Or
a
is that just a
standard
$44,000?
$44,000 under the federal law. Yeah. Okay. Got to pay them retirement benefits of $44,000. Now, college, I will tell you, some institutions of higher education that receive federal funding can actually offer tenured faculty member voluntary early retirement packages without violating the ADA. And I won't get into all of the specifics of those, but that can be done. Somebody, and again, bona fide occupational qualification, we talked about that, is always a defense. Now, somebody asked me, is it an age discrimination not to promote somebody who's getting ready to retire? Okay? So if you have somebody, let's say, that's 62, getting ready to retire and is about 6 months or so from receiving their Social Security benefits, can you go ahead and deny them a promotion? I think the answer to that, well, let me ask you this. What do you think the answer to that is?
Well, are they for sure going to retire in 6 months?
Let's assume they are.
Then I would say that you can deny them the promotion because they're only going to be there for 6 months.
Absolutely. I think you're absolutely right. If you know for sure that they're going to retire, if they've already said, I'm going to retire when I reach 62, I think you could not offer them the promotion because based on their own words, they've said they're going to retire when they get 62. And why is that not discrimination?
Because they've already stated that they're going to retire. So you as an employer want to fill the position for the long term and not just for 6 months and then go look for another person to.
Absolutely. It costs money to train. It costs money to put people in new positions, even though it's a promotion. Turnover is expensive. When they turn over, you're going to have to provide somebody else. Yeah, I think in that case, if you knew for sure that they were going to retire, I think you could hands down say you're not going to offer them the promotion without it being discrimination. The danger there is you better make sure you got some pretty good facts because otherwise you might be sued. And so it's the defense of the lawsuit that's going to cost you. The other thing about age discrimination, it is okay to terminate somebody for economic reasons. And what I mean by that is frequently older people get terminated. Why?
They'll have less time remaining in the job force.
They'll have less time remaining in the job force, okay? But as a company, I don't really care. You know, let's say as a company, I don't care about my people. So I don't care whether you're going to work there, whether you're going to get another job or not after I terminate you. Why else might I want to terminate you for the good of the company?
Maybe they're earning a higher salary.
They're earning a higher salary. Yeah, most people who are older and have been with the company for a long time get a higher salary. And because of that, okay, it is okay to terminate them if you're doing so for economic reasons. Here's the catch. You pretty much have to do it one at a time, okay? In other words, let's say I come into this room and I'm looking at a bunch of 62-year-old people in front of me, okay? I probably can't just say, guess what? I'm getting rid of all of you and I'm keeping the young, cheerful, happy people in West Plains, okay? But if I do it selectively, if I say, Patrick, you're just making too much money, going to get rid of you. Day, you're making too much money, going to get rid of you. And I don't do it as a blanket policy, then I'm going to be able to get by with it. Okay? So it's not based on age, it's based on saving the company money. And it just happens to be that those who are older are who affected. Okay? All right. Now, last thing with regard to age discrimination that I want you to be aware of is what we call the Older Workers Protection Act. The Older Workers Protection Act. And instead of getting into that mandatory retirement, this is where most older workers are protected when they are, as they are leaving the workforce. It allows, this act, the Older Workers Protection Act, allows workers to waive their rights. So they can waive their rights to age discrimination claims or any other claim. But that waiver must be made knowingly and voluntarily. So the waiver has to be knowingly and voluntarily. It has to be part of a written agreement. It has to be written in clear language. It must specifically mention the claims being waived. Anybody need me to stop and go back yet? Or everybody okay? Okay. It must specifically mention the claims being waived. So if I'm dealing with somebody 62 years of age, what do I want to say in my release right now? With what you've gotten so far? What am I going to tell them they're giving up? Any claims they have under the federal law, but let's be more specific than that, because if you just say federal law, you probably don't cover, it probably doesn't cut the mustard under this act. The ADEA, yeah. You have to spell it out, okay? So you have to say, and that's why if you've ever seen a release, it will spell out every law that there is. It will spell out the ADEA. It will spell out Title VII. It will spell out the specific state law, usually, and may even mention other laws as well, okay? In addition to specifically identifying the claims, has to provide additional consideration. And what do we mean by consideration? Payment. We've got to give them the money. Okay? Have to give them the money. The other things, three more things. Must advise the employee to consult an attorney. Must advise the employee to consult an attorney. And when I was in private practice, frequently people would call me up. They would say, I have an agreement that I've been asked to sign. Can I talk to you about it? And we'd set up an appointment and they'd come in. And basically what I wanted to find out is how good of an age discrimination claim did they have? And if I didn't think they had a really solid claim, or any other claim. You see it not only, although these are geared toward older workers, it can apply to anything, race, whatever. So if they weren't in the protected class, I'd still, do you have a sex discrimination claim? Do you have a race claim? Whatever. But I wanted to find out what kind of claim they really thought they had, talk to them about it, because frequently I was telling them that if they didn't sign this money, what would happen? What were they going to get as far as payment, right, if they did sign this money? If they didn't sign the release, what were they going to get as payment?
Nothing.
Nothing, all right? So I'm in the position of saying, if you don't sign this, you don't get any money, you better make sure that you've got a valid claim. Okay? You got to make sure you have a valid claim. So we advise them, or the document has to tell them to consult an attorney. Then two more things. It has to give them 21 days to think it over. Has to give them 21 days to think it over. And then finally, must allow them to revoke within 7 days. What do I mean by that?
If they change their mind, they can take it back.
Right, yeah. So you got to tell them consult an attorney, give them 21 days to sign it, and give them 7 days after they sign it to revoke. Now, in case you're curious, they don't have to wait the 21 days to sign it, okay? So if I give them this, and if I give Kyle this, and Kyle says, I appreciate the chance to consult an attorney, but I've sat through Law 531. I don't need to consult an attorney. I'm going to sign it right now. Can I pay him in 8 days? Absolutely. Can I pay him in 6 days? Well, I can, but guess what? And there are cases out there where people haven't followed this, or employers haven't followed the Older Workers Employment Protection Act, paid out 30. There's one case where they paid out $40,000, didn't follow the act, got sued, and guess what? They weren't able to get the money back. Okay? Now, the employer could have said, well, you've already been paid $40,000 of that, and therefore, so if we have discriminated against you, we can use that. But bottom line is they still got sued. Okay? And the employee still walked away with their money, minimum. But yeah, I don't have to wait 21 days, but I want to wait at least 8 after, or pay them on the 8th day after they've signed it. Okay. Tough cases to win, but a lot of discrimination cases are. Okay. Any other particular questions with regard to national origin or disability? Jackie? Yes? No?
Yeah, whenever you said that they can both be in the protected class as far as age, and you can still have a claim, that's only if the person hired is younger, right? Not if it's the reverse.
I don't want to say never, but I think you would have a very hard time proving. I can't imagine. I would never have taken a case where they were replaced by somebody older than them. So I think I've never seen any cases out there. I don't want to say that I couldn't create a situation.
Of course you're a lawyer.
Yeah. I could probably create a situation, but for the most part, I don't want to go into court because as an employer, I'm going to want to say, I don't know what they're talking about. It's not their age. Here's somebody who's 5 years older that we hired. Yeah, I think it's almost always going to be when the person in that protected class is younger than the person sitting. Now, that's a good point. Okay. All right. Any other questions? All right. So far, as we finish this unit, we've talked about religion. We've talked about national origin, immigration, and we've talked about age. So we'll finish up next week with disability.